court case, and this is after the recusal of the magistrate in Vusimuzi Mahlangu. Let's listen in.
As well, Your Worship, that in the gallery, and I'm going to request Mr. Tefo to come closer. There's also Advocate Tefo, who just approached me, Your Worship, that he also wants to make an application to be a friend of the court, Your Worship. I don't know at what stage the court will accommodate that, whether we should start with Mr. Tefo's application as an amiras curiae before we get into the other applications. May Mr. Tefo introduce himself into the record.
Morning, Your Worship. Yes, my name is Big Tefo. What brought me here, Your Worship, is that I want to bring the application for amicus curiae to be the friend of court. Let me say simple terms, not the same much of that last year. To be the friend of court in this matter. The reason is that I'm informed that the accused they are here to apply for the realization of their bail conditions. So, as a result of that, first, I'm also the accused. Another matter, whereby your brother is appearing, acting chief Mahlangu. My matters come on the 22nd of October, next week Tuesday. So the reason for me being here and bringing this application is on the basis of the fact that the applicants are very dangerous people. I was in jail. They are part of sending me in jail. And when I was in jail, they were monitoring my communication in jail. Whereby Mr. Kumar, the Divisional Commission, accused number 1 in this matter. He appointed Brigadier Moyano.
Your Worship, with due respect to my learned friend, there is no application, substantive application that has been brought before this court on papers for the request for my learned friend to be accepted as a friend of this court and to be able to stand before this court and be able to address this honorable court regarding the issues implicating my clients before this court. And therefore, my Lord, I ask that my learned friend be not allowed to address his lordship on the grounds and basis upon which he wants to apply as a friend of this court. And above that, the application will be opposed. In criminal law, we never have had such an advocate who wants to join the proceeding as a friend of the court. In civil court, yes, we do know the proceeding. It does happen like that. And my clients will be prejudiced should this court allow my learned friend, Mr. Tefo, to continue placing on record the allegations that he wants to place on record. And it is prejudicial, it should not be allowed. He cannot be allowed even to get a platform to address his lordship regarding such application. That is not proper before this court. Those are my submissions.
May it please the Honourable Court. Your Worship, I'm also of the respectful submission that learned friend Mr. Tefo should file his application with the clerk of the court and serve copies of his application to us as the state and to the defense so that we can have insight into what the application is all about, and we can then respond and set out whether what our view is regarding his application. I'm afraid that already he was going into the merits of what his issues are about without us having had sight into his papers. It's not that we've already made a decision on whether we're going to oppose or not, but if the court can make an order that we already have a date on which the case has been postponed to. Mr. Tefo can be given time frames on when to file his papers, and then the other parties can then respond. Okay.
Mr. James, do you have any response to the objection?
Your Worship.
Do you have a response to the objection?
I do have a response, Your Worship. Yes. Your Worship, I'm appearing here not as the counsel, as an applicant who is a normal citizen in this country, law-abiding citizen, who has been harassed and been persecuted. So hence I'm saying, I'm not objecting to that. I was saying that if I cannot seize this opportunity today, Your Worship, I'll be overtaken by the events. Because if this court can proceed to extend that the application of the applicants here be granted, that the bail condition be relaxed, because chief among the bail conditions that
Yeah, and those issues, I want to reply to the objection which issues of being allowed to bring the proceeding and the report.
Just the last thing. Just the last thing, is that yes, I was fearing that I may be overtaken by the events if I come later. So I'm amenable to bring the application in writing. So if this is not going to happen today, there will be a postponement. Then I'll be fine, and the court can make a ruling in terms of release the 125 and all those things.
At this stage, I will not make a ruling as to whether or not a person can join criminal proceedings at the end of the court. But if you can afford to bring an application, I think it's a sufficient condition for the minister that you must bring a substantive legal application and must send Mr. Smith and Mr. Jordan the copy to the application. So at this stage, the application cannot be had.
Yeah. And it's very important also to highlight this point. I'm also objecting the inclusion of the council in Sholola itself.
No.
That is, I will address him.
I've made a ruling, that is the end of it.
Okay.
Mr. Smith.
As the court please, you should back to the main matter which is before this court. In brief, the accused 1, 3, and 4 in the main case are applicants in this matter in terms of Section 63 to amend a bail condition which was set by your brother, Mr. Mahlangu. The proceedings started on 22nd of August 2015 and postponed to 2 other dates, and yesterday on the 14th of October, Mr. Mahlangu then recused himself from the proceedings on the basis of the events that are happening at both the Madlanga Commission and the parliamentary portfolio proceedings. He then informed us yesterday in court of his reasons for recusing himself, and that's how then the matter was then reallocated to you as a new presiding officer in the case. We have since, as the state's team, looked into the decision of Mr. Mahlangu to recuse himself, and we are of the respectful submission that it ought not to have happened the way it did, and that it's not in compliance with Section 22 of the Superior Courts Act, and therefore, on those bases, we intend to make an application to the High Court to have the decision of Mr. Mahlangu recusing himself from these proceedings reviewed and set aside. We have already compiled our papers, Your Worship. This morning, the investigating officer just deposed to an we are on our way to the High Court to settle. We have a copy that we can show to the court as proof of what we're going to file. And as a result, we are not in a position to start with a new Section 63 application today, since we are reviewing